Hello, everyone. I'm HearMeowt. Welcome to my channel. Judge Jackson has finally spoken. We have her orders on the Brian Boone versus Sarah Boone Family Law hearing, or thrashing, depending on which side you look at it from. Is Sarah Boone going to finally get her $62,000 in back alimony? Has she finally gotten court-ordered access to continue harassment of her ex-husband Brian Boone and their son? Or is Brian and son going to finally get some sort of relief from the court from the human migraine that is Sarah Boone? Were there any surprise rulings? Will everyone be happy with it? I don't know. I will read the entire document through one time first at the beginning, and then go back through it section by section, providing commentary for those who care to hear my opinion. So without further delay, let's get all the questions answered right now. Let's go. Hello, everyone. This stream, I set this up 7 months ago. It is so old. Look at that. The old intro was recorded 7 months ago. I had to clip off the end, worried that it would copyright strike me for that song that I had back then. But you are all here for the same reason. Let's get going here. So I know I said in the thing I was going to read it once through and then provide commentary. That's what I thought I would be doing 7 months ago, but it's 17 pages. So we're going to go through it line by line for all the important stuff rather than read it all through. It's 17 pages. I'm going to read it through bland the first time. First overall impression is it's exactly what I thought it would be, and I like it, but let's reduce the spoilers for everyone. And if you're watching this on the replay crew, I will put chapter markers. And I'll put one in like with, result at the end if you're just looking to get the high level result of what it is. Okay, everyone ready? Let's go. Brian C. Boone versus Sarah Boone. Supplemental final judgment on modification and relocation. This cause having come on August 5th, 2025 for consideration of petitioner, blah, 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 blah. And mother, who's responded. So we're deciding on supplemental petition for modification of final judgment, the original divorce agreement, verified petition to relocate permanently. Remember, because it's only temporary right now. Sarah Boone's motion for contempt, and I guess it's kind of spoiling it, but petitioner seeks modification of the party's final judgment and relocation to Gainesville with the minor child. Petitioner's modification petition is granted in part. Petitioner's relocation petition is granted based on the following. Okay, so he can stay in Gainesville. That part is granted, and that his modification is granted in part. In his modification petition, petitioner seeks a modification of shared parental responsibility for the party's minor child, the termination of alimony, the termination of child support, and attorney's fees and costs. And this is background. On June 15th, 2018, this court entered a final judgment of dissolution of marriage that adopted the party's marital settlement agreement and parenting plan that were filed May 9th, 2018. The parties were awarded shared parental responsibility for the party's minor child, and petitioner was ordered to pay monthly child support of $100 and durational alimony of $1,000 per month for 84 months. In his modification petition, petitioner alleges that the final judgment should be modified due to a substantial change in circumstance. Why did that highlight? I don't want that to highlight. Like that. At least highlight yellow. Yeah, dude. Substantial change in circumstance, to which respondent, quote, was arrested and charged with second-degree murder of her boyfriend. Oh, Sarah. The The party's minor child has lived exclusively with petitioner since respondent's incarceration, and respondent, quote, does not have the financial need for alimony or child support. Respondent filed a 9-page handwritten response, quote, modification answer, on May 16, 2022, generally denying all of petitioner's requests for modification rather than responding to each paragraph of the modification petition. Of course she did. A, substantial change in circumstances. It is undisputed that the respondent has been incarcerated since February 25, 2020. The subsequent to the filing of the modification petition, the respondent was convicted of second-degree murder. Uh-oh. Now the judge is saying it. And she was sentenced to life in prison. Oh. Nine, it is also undisputed that since respondent's incarceration in February 2020, respondent has not exercised any regular time sharing. Is there a footnote on page 1? I don't think so. Oh, we're still on page 1. A parent's failure, this is quoting another case, parent's failure to regularly exercise the time-sharing schedule set forth in the parenting plan shall be deemed a substantial change of circumstances for purposes of modifying the child support award. Florida Statute 61.30. The alimony, and here's the footnote, first one. The alimony payments were started on May 1st, 2018, making the 84th and final payment due April 1st, 2025. April Fool's Day, if you will. In anticipation of the entry of the original final judgment, respondent made financial disclosures averaging? I've never heard that word. Averaging? Whatever. Averaging that she was receiving unemployment benefits and in search of a job, and she alleged $5,293.83 in monthly expenses, leaving her with a financial deficit of $4,521. Does anyone know what that word means? Averaging? I mean, I can figure out what it means from context, but undoubtedly, neither party contemplated respondent's arrest and incarceration when their marriage settlement agreement was entered and their parenting plan was agreed upon. Oh, no. Well, that's not her fault, she would say, right? Doesn't say anything about incarceration in that. Okay, it means declaring. Oh, is it avowing? And well, why is it? Whatever. I mean, clearly it says AVERRING, but the court finds that at best, respondents' reasonable monthly expenses since incarceration total $145 per month. Oh. Sarah, she's not gonna like that. She needs way more than $145 a month for honey buns alone. Her honey buns budget is at least double that. All right, let me put this on the little sheet here. My notes. It's out. $145 expenses at most for Sarah per month. Oh, I hate it when I can't do it. Alt tab sharing screen. All right. As such, substantial competent evidence supports Petitioner's claim of a substantial change in circumstances. Well, that surprises no one. And case law. What is this? Henry versus Thomas, finding that incarceration clearly constituted a substantial change in circumstances. Well, duh. Footnote 1. So this is a footnote to this sentence here. To this amount includes $16.67 for clothing, based on respondent's admission on cross-examination that the $50 clothing expense is charged quarterly, $15 for medical dental expenses, $70 for hygiene, which is whack. She's disgusting. She's not using it for hygiene. In writing items, okay, yeah. Based on respondent's testimony that the prison does not pay for basic hygiene items like an all-in-one shampoo/body wash, toothbrushes, and toothpaste. And $43.33 based on testimony of a $5 cost for a 30-minute call and allocating 2 calls per week. Now, you know, I thought it was only 1 call, whatever. Oh, maybe just not to her son. The court does not find credible respondent's testimony that she needs $250 per month for snacks because of her stomach not handling meals properly. Oh, Sarah. Oh. Sarah's not going to like that either. I could just picture her reading this, just losing her mind. What do you mean it's not reasonable? She admitted on cross-examination that the prison provides free breakfast, lunch, and dinner. She provided no competent, substantial evidence of any medical issues resulting in, quote, low blood sugar that would necessitate the need for snacks between her free meals. Oh, why doesn't tab work? Further, respondent did not identify to which creditor she was making payments, and she denied owing the Department of Corrections $50. Is this still on screen? Yeah, okay. While mother lists as gifts expense, the court found credible father's testimony that he purchases most gifts for the child on behalf of mother, and both parties acknowledged that father pays for all calls between mother and child. Yeah, you did admit all that on the stand, didn't you, Sarah? So that's where we're getting the 145 at most. 16, 15, 70. That's about 143 and 5. At most $145. B, parenting plan modification. Petitioner seeks to modify the finally just. Is Adobe doing something weird here? The final judgment by awarding him sole parental responsibility, decision-making, and 100% time sharing. That's what he seeks. At the final hearing, father proposed mother have 1 monthly visit and 1 weekly call with child. Mother objected to father's request for sole parental responsibility, and she requested an unspecified number of, quote, phone calls and personal space without interference, as well as 1 to 2 in-person visits for the, quote, maximum time allowed, holiday visits, and perpetual cooperation from the father. Judge Jackson's just digging at her with these quotes. Yeah, go ahead and appeal it. The Court of Appeal is going to see how stupid you are. The court has heard the testimony of the parties, examined the demeanor, body language, and overall credibility and ability to show self-insight and awareness of the issues pertaining to shared parenting and time-sharing issues, and examined evidence related to the issue of the contested time-sharing for the minor child. Wow, a lot of stuff in here, that sentence. Body language, she's going to say, no, I wasn't there. How can you see me? Overall credibility, though, Sarah, ability to show self-insight and awareness. It doesn't sound like Sarah at all. In determining the best interest of the child, the court makes these findings as to the factors affecting the welfare and interests of the minor child in the circumstances of the family as follows. Some of these we're going to skip because it just says like no evidence was presented on this. But A, the demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, to honor the time-sharing schedule, and to be reasonable when changes are required. Due to her incarceration and life sentence, there it is again. Sarah's not going to like that. Mother has been and continues to be unable to honor the time-sharing schedule implemented by the parties' parenting plan and the final judgment. The child was able to have virtual visitation with mother when she was incarcerated at the Orange County Jail, but she has since been relocated to a prison in Marion County. Oh, no more virtual visits, Sarah. Father testified that he has paid for all telephone calls between mother and the child. Adobe's got to be doing something. There's typos everywhere in this. Come on, ISIS? Is this the work of ISIS or clerk? According to father, there are times when the child is visibly upset after speaking with mother on the phone because of the way mother talks to child. B, the anticipated division of parental responsibilities after the litigation, including the extent to which parental responsibilities will be delegated to third parties. Since mother's arrest in February 2020, father has undertaken 100% of the responsibilities of the child. Now, she's not going to like that either. Her son needs her. Her son desperately wants her. C, the demonstrated capacity and disposition of each parent to determine, consider, and act upon the needs of a child as opposed to the needs or desires of the parent. Well, I wonder how much blindness Sarah will have reading this. There's nothing written on this page. The court notes that mother continued to contest the relocation petition and subsequent motion for temporary relocation despite the intense local media coverage of her trial, despite the child being bullied in school in Orange County. See temporary restriction. Entered on April 5th, 2023. Finding mother did not have an articulable reason as why she opposed relocation. Well, it's because she hates Brian. She can't just say that in court, though. The length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. See, she's going to object to this. It's not satisfactory. Look at what her son will tell you. Since mother's arrest in February 2020, the minor child has lived with father 100% of the time. The geographic viability of the parenting plan, with special attention paid to the needs of school-age children and the amount of time to be spent traveling to effectuate the parenting plan. The parties disagree, no kidding, as to how many phone calls and prison visits the child should have with mother. Father contends that it is 1 hour, 20-minute drive from Gainesville in the facility where mother is currently incarcerated. Mother estimates that it's a 50-minute drive. However, this court finds father's testimony and travel time to be more credible as mother has never driven from father's home to the jail. Son of a bitch. And mother's 50-minute estimate appears to be a generalization of travel between Ocala and to Gainesville without taking into consideration of traffic and the actual distances between destinations. Oh, Sarah. Moral fitness of the parents. It's a big one. Father has raised concerns regarding mother's inability to show genuine and accountability or remorse for her actions that led to her conviction for second-degree murder and subsequent life sentence. in prison without the possibility of parole. Oh, Sarah's not going to like that at all. We don't even know if it's natural life. The mental and physical health of the parents. No evidence. Yeah, okay, so. We've got to move this window over. 1 second. The home, school, and community record of the child. The child currently attends, I'm not going to say where he goes out loud. The school is located 11 miles from father's home, and father is responsible for 100% of the child's transportation to and from school. Okay, we got an NA here. The reasonable preference of the child if the court deems the child to be of sufficient intelligence, understanding, and experience to express a preference. NA. This tells me that she didn't talk to L. Because if she had, he clearly would have said, I want to stay with mommy in prison. No evidence in this one. No evidence present on this one. Let's get this. The demonstrated capacity of each parent to communicate with and keep the other parent informed of issues and activities regarding the minor child, and the willingness of each parent to adopt a unified front on all major issues when dealing with the child. Now, I bet you when Sarah is reading this, she's thinking, here's where I got him. Here's where I got him. Because he doesn't communicate at all. He never even responds. There exists a vexing communications problem between the parties. Yeah, no kidding. Vexing. I'm often vexed, but the judge was also vexed. There exists a vexing communications problem between the parties due to mother's incarceration. Wait, no, it's not her fault. Why are you blaming this on incarceration? She didn't even want to be arrested. This is Brian's fault. Oh my God, this judge is so biased. Father is unable to pick up the phone and call mother to discuss day-to-day parenting and decision-making issues. Yeah, he doesn't even pick up the phone when she calls, though. This makes it difficult for the parties to confer with each other so that major decisions affecting the welfare of the child will be determined jointly and expeditiously. According to father, he sometimes receives calls from mother asking him to buy things for the child or yelling at him.
Son of a bitch.
Father also testified that he has not received any letters from mother in 4 years. So I think, this is obviously being misinterpreted or misunderstood by the judge. Sarah clearly said when she was questioning Brian, how are you going to get a hold of me in an emergency? Right? You don't have a way of doing that. Sarah was doing that to show how irresponsible Brian was, that you wouldn't have a prisoner on speed dial for an emergency. Court, on the other hand, finds that it's probably because you don't need to involve a prisoner during an emergency. No evidence. Okay, this domestic violence, no evidence presented. I don't want to highlight that. Evidence that either parent is knowingly provided false information to the court regarding domestic violence. No evidence presented as to this factor, although I would consider, she's lying, but maybe not about violence, but she considered it violent when she said Brian calls her a murderer. Killer. The particular parenting task customarily performed by each parent and the division of the parental responsibilities before the institution of litigation and during the pending litigation. Institution. Litigation. Wouldn't it be like initiation of litigation and during pending litigation, including the extent to which parenting responsibilities were undertaken by third parties. While the final judgment provided the parents were to have 50-50 timesharing, father estimates that mother exercised 30% of the timesharing. Oh, no. You just going to take his word for it? He testified that mother's timesharing was sporadic and she saw the child whenever she felt like. According to father, there were nights when he got calls to pick up the child because mother had started drinking. So I don't know if you're noticing a pattern here, but this doesn't seem very good for Sarah so far. The demonstrated capacity and disposition of each parent to participate and be involved in the child's school and extracurricular activities. Well, that's what Sarah wants. Due to her incarceration, mother has been unable to participate in the school and extracurricular activities. Yeah, that's her problem. That's the problem, Judge. You need to make sure that, she can get picked up or have everything recorded. Like just have him wear an iPhone on the front of his head, like a FaceTime, so she can constantly see what he's doing. Let's see. Demonstrate capacity, maintain environment free from substance abuse. No evidence presented. The capacity and disposition of each parent to protect the child from the ongoing litigation as demonstrated by not discussing the litigation with the child, not sharing documents or electronic media related to the litigation with the child, and refraining from disparaging comments about the parent to the other child. Yeah, exactly. Like when she called her a killer. There was no evidence presented as to the parties discussing the current modification proceeding with the minor child. But mother testified that father has called her a killer and murderer in front of the child. Finally, the judge hears Sarah's plight. And I'm not sure about this statement. No evidence. I mean, I guess no evidence was presented, but there's plenty of. Just reading through between the lines on the topic she talks about when she's screaming. The developmental stages and needs of the child and the demonstrated capacity and disposition of each parent to meet the child's developmental needs. The child is 14 years old, enrolled in a magnet program, and involved in extracurricular activities. Any other factor that is relevant to the determination of a specific parenting plan, including the time sharing schedule. Father testified that mother has not been involved in any major decisions regarding the minor child. Right. That's Brian's fault, as Sarah would say. She wants to be involved in every decision. Also, he has no idea how to contact mother to get her input on issues involving the child. Sarah brought that up, but not the way you're using it. He testified that over the past 6 years, mother's calls have been on and off. He describes there being weeks of tons of calls, but other weeks with none. He also expressed concerns about mother's decision-making, including the circumstances leading to her arrest and her conviction for second-degree murder. Sarah's not going to like that. According to him, he doesn't think she makes good decisions. Notwithstanding his concerns, father testifies he does not mind mother giving her input on decisions regarding the child's education, health, and other major decisions. But he believes sole parental responsibility is in the child's best interest, given mother's current circumstances. I think she could have thrown another dig about being incarcerated for life. I didn't miss a footnote on the last one, did I? Okay, yeah. All right, here we go. Upon evaluating the factors above, it is in the best interest of the child that the father have sole authority to make major decisions for the child. Yeah, okay, that's good. That's good. Oops, nope. It is detrimental to the child to have shared parental responsibility for the following reasons. Mother's current incarceration with a sentence of life in prison, without the possibility of parole. Mother's sporadic calls and father's inability to call mother to discuss parenting issues. It is in the child's best interest for father to have 100% time sharing with the minor child. All right, there we go. That's good too. The court further finds that a flexible visitation schedule for mother is in the child's best interest of the child due to his age, current school schedule, extracurricular activity commitments, and the distance between the child's home and the prison where mother is currently incarcerated. So I'm thinking that some people didn't like this part at first because she's getting visitation, but it's flexible visitation schedule, meaning what the child can do. All right, let me put this in the notes. I'll check the super chats for a sec before we move on to alimony. But if you're here, why don't you go ahead and hit the like button and subscribe if you're not already. Share to Brian. All right, let's see these super chats a sec. Katrina Dancer, new member, welcome. Missy Lou, $5. Thank you very much. LFG, let's go. Thank you. Lynette P150, I'm coming in late. Gonna back up to the beginning. Wee! 999 super chat. Thank you very much. Wait, did I show that? Oh, disappeared. Sorry, I didn't show it on screen, I don't think. All right. Back to the document. Alimony termination / modification. Petitioner seeks the termination of the durational alimony, or the alimony be reduced or at least suspended during respondent's incarceration, which is for life up here, sentenced to life in prison without the possibility of parole. At the final hearing, respondent argued she needs alimony to buy gifts for the party's child, and she is legally entitled to alimony. Putting that in quotes. This was her argument. I need to buy gifts for my son, and I'm legally entitled to it. That's my legal defense. Yep. Yeah, no spoilers. Remember. However, neither party waived their statutory right to seek modification of termination of the alimony award. Yeah. Meaning we can revisit it, Sarah. I mean, this also think we've been listening to the calls, right? This document represents everything Sarah has been fighting so hard for. The amount of an award of durational alimony may be modified or terminated based on a substantial change in circumstances. And we already know that there has been substantial change. The court finds the respondent has zero income due to her involuntary incarceration. Okay, at least you gave tip of the cap to Sarah there. We know it's involuntary, Sarah, and that a reasonable monthly expenses or reasonable need has been reduced to $145. By stipulation, the court finds the petitioner's gross monthly income is $5,000 and has the ability to pay alimony. Yeah, they stipulated to that. Because respondent still has a need for economic assistance, petitioner's request for termination or suspension of his alimony obligation is denied. Now, everyone just calm down. She's saying you can't just cancel it outright because she does have an economic assistance need, the $145 a month. Everyone just chill. See Florida statute, especially stating the purpose of a durational alimony is to, quote, provide a party with economic assistance for a set period of time following the marriage. However, petitioner's request for a downward modification of his alimony effective May 1st, 2022 is granted. Yay! So that's good. That's what, like I said, like this pretty much follows exactly what I thought it would be, right? So we can lower the old alimony for the remaining 36 months of the 84-month period for durational. There's typos. For the remaining 36 months of the 84-month period for durational alimony, the obligation shall be modified downward to $145 per month for a total of $5,220. Yep. Respondent is entitled to total alimony arrears of $20,220. Now you're saying, where did that come from? Well, was stipulated in court. Remember, he stopped paying in 2020 through May 1st, 2022. That 1,000 stays in place. The 15,000. Now you add the 5,220 from May 1st, 2022, which ends up being 3 years, right? Because it would have been through April 1st, 2025. Well, that's when the final payment would have been due. So that's 3 years. That's where we're getting the $20,220. But everyone relax, because we're not done yet. Child support modification. Actually, I gotta put this in my notes. 2,000 or 20,000. Child support modification. Oh, footnote. So this is 3. This would be in relation to where's note 3? Termination or suspension. Note 3. Respondent is currently sentenced to life in prison without the possibility of parole. Just rubbing it in over and over. As such, petitioner's request to suspend his alimony obligation while petitioner is incarcerated is effectively requesting a termination of the alimony, because she's never getting out, right? So that's why it's termination, not a suspension. Petitioner admits that he did not make any alimony payments for the 15 months before filing the modification petition, for a total of $15,000 in missed payments. Yep. They stipulated to that, so you knew that was coming. All right, modification of child support. Father also seeks the termination of child support, retroactive to the date of mother's arrest, because his child support obligation was based on the equal time sharing schedule outlined in the parenting plan and on the financial abilities of the parties at that time. It is undisputed that the mother stopped exercising time sharing with the minor child upon her arrest in February 25, 2020. Yeah, undisputed. After over 3 years of litigation, mother finally conceded during the final hearing that the final child support obligation should be terminated, given her incarceration and exercise of 0 overnights. I don't know that she agreed it should be terminated. She wanted to have control when they're filing. She still wanted to delegate where that $100 was going, right? During the final hearing, father testified that the clerk was holding approximately $4,000 in child support payments because the clerk did not have information and or address to where the child support payments could be made to mother. Sarah is terrible at updating her addresses. Mother agreed that all such funds being held by the clerk of court should be returned to father. That's generous. She wanted to delegate where that money went. So, $4,000 coming back to old Brian dog from the state. So, put that in here. $4,000. Child support funds returning to Brian. Petitioner's request to terminate his child support obligation effective February 25th, 2020 is hereby granted. All right, so you got another W. Yeah. It's retroactive to the date the non-custodial parent first failed to regularly exercise the court-ordered or agreed time-sharing schedule. So it's not back to when he filed to modify it. It's when she stopped exercising her rights. The new child support arrearage balance is $0, effective April 7th, 2026. Relocation petition. In his relocation petition, petitioner seeks to permanently relocate from Orlando to Gainesville because of respondent's incarceration for second-degree murder, the child being bullied at school, and respondent having 0 overnights over the past 3 years. On February 23rd, 2023, respondent filed a handwritten response, relocation answer, to the relocation petition, wherein she objected to the relocation. Notwithstanding her objection, on April 5th, 2023, the court entered its temporary relocation order, wherein the court permitted petitioner to temporarily relocate to Gainesville. Respondent continued to contest the permanent relocation, did not stipulate to the permanent relocation until the final hearing. Yeah. The court finds that the permanent relocation to Gainesville is in the best interest of the child, especially in light of mother's current incarceration in Ocala. Yeah. As such, the relocation petition is granted by agreement of the parties. I don't. Wait a minute. There's no agreement, though. She didn't agree to that. She didn't agree to that. Okay, before we get to the motion for contempt, check here. Remember to, for those of you just joining us, hit the like button if you enjoy this. Polynomial purebred, $9.99. For each visit, I want Brian to sit and view and out of reach of her mukbang for the entire time from the vending machine food and eyeball her the whole time. Snickers bar so good. Cheetos yummy. Oh, Sun Chips. You want one, Sarah? Oh no. NP Viz Queen, $2. $145 is only 58 honey buns. I love this for Brian Boone. Well, she doesn't, but you understand the 145, there's not even room for honey buns in there. That's all going to just basic expenses. The judge seemed like she didn't believe the blood sugar thing. Okay, Evermore gifted 5 Hear Me Out memberships. Congratulations to those who received them. And if you did not, remember, membership is only $1. And I just posted 4 member. Gotta love that back button. Gotta love that back button. Share the screen again. Why is IQ not activated? StreamYard really just destroys how normal computers react. Okay. Sarah, okay, now we're getting to Sarah's motion for contempt. Remember, she wanted contempt. I want to be held in contempt. I want him sent to jail. He should be in here, not me. Motion for contempt. Although most of her motion involved the respondent writing about her displeasure with the court's ruling permitting temporary relocation over her objection, respondent does state she is seeking to obtain, quote, missed, delinquent, or diminished alimony payments. Well, we already know you're not getting that. Petitioner acknowledges that he did not pay $15,000 in alimony for 15 months between respondent's arrest, February 2020, and the filing of his modification petition. While petitioner acknowledges that he stopped making alimony payments after respondent's arrest, petitioner testified that he did not pay alimony because after the respondent's incarceration, he had nowhere to send the money. He helped move items from petitioner's apartment upon her incarceration. He paid for a storage unit. This is double spaced. It's typo. For items, and he made $600 worth of direct and or in-kind payments to petitioner prior to the date of filing, including giving respondent commissary money. Now, it says 600 here, but the way it's written, it sounds like it's a one-time thing, but I thought it was 600 a month. While the court does not find that petitioner's post-incarceration gestures absolve him from his alimony obligation, the court cannot find an intentional and willful violation of the final judgment under these unique circumstances. Oh my God, she's so biased. Including back it up. The court cannot find an intentional and willful violation of the final judgment under these unique circumstances, including respondent's long-term incarceration, petitioner's inability to make Zelle payments, and respondent's lack of a bank account that she can access. That's Brian's fault.
Son of a bitch.
Brian had just kept sending her money, her bank account of 30 years wouldn't have closed. Judge, how did you miss all this? As such, petitioner's motion for contempt is denied as to contempt, but granted as to enforcement of petitioner's $1,000 alimony obligation, $1,000 alimony month obligation for the 15 months prior to the filing of the modification petition for a total of $15,000. So that's where that 15 with the 5,220 gets us up to $20,220. Everyone following along? Okay. Request for attorney's fees and costs. Petitioner seeks an award of attorney's fees and costs. Specifically, petitioner seeks $12,000.50 in attorney's fees and costs through July 29, 2025, as well as fees and costs for the preparation and attendance of the trial. The court evaluates the following factors under Rosen v. Rosen. Financial resources of both parties. Petitioner is an out-of-work software developer, but he's stipulated to imputed annual income of $60,000. While he owns real estate and has tangible assets, the extent of his liquid cash is $1,306 in a trust checking account. See petitioner's financial affidavit on April 25th, 2025. Respondent, no ongoing monthly income, but she is entitled to $22,220 in alimony arrears. No, this is a typo. You have $15,000, then you have $5,220. What is with this motion or this order? That's wrong. It's $20,220. Or am I going crazy here? Where is it? Okay, I can remember it in my own brain. $15,000 and $5,220 is $20,220. Not, there it is, $20,220. Not $22,220. Mistake. The initial dissolution proceeding took 197 days from the filing of the petition to the entry of a final judgment. The divorce, basically. The divorce took 197 days, which included the distribution of real property, equitable distribution, time sharing, parenting classes, parenting plan issues, child support, and alimony. There was little to no activity in the court file from the entry of the final judgment until the filing of the modification petition. Finish reading it and go back to the footnote. The scope of the post-judgment proceedings involved relatively straightforward issues on child support and alimony modifications/terminations, as well as the temporary and permanent relocation to which respondent eventually consented after years of objecting. I don't like where this is going for Sarah. Footnote 6. So this is to here until the filing of the modification plan. There's a letter from the clerk's office to respondent. Clerk letter filed April 12th, 2021, wherein the clerk notified the parties that, quote, records indicate that the clerk of Kurt, I get pranked, clerk of court, does not have a correct address for respondent on file and is unable to send child support payments. And thank God she didn't update her address because she never got that money. Idiot. 145 includes the price of 2 calls a month, 2 5-minute phone calls. I don't know. not necessarily to her son. Duration of the litigation. The post-judgment proceedings for which petitioner is seeking attorney's fees unnecessarily spanned 1,231 days. Yeah. From the date of filing of the modification petition to the final hearing on a relatively straightforward issues. Yeah. Yep.
Son of a bitch.
Merits of the respective positions. Petitioners raised meritorious issues in seeking the termination and or modification of child support and alimony due to respondents' incarceration for second-degree murder, and lack of exercising time-sharing. Likewise, petitioner's basis for his request for location, this should be relocation, in part due to the media coverage of respondents' murder charges, which lead to the minor child being bullied, was also meritorious. This should be led, not lead. It was also meritorious. On the other hand, respondents' failure to acknowledge a substantial change in circumstances, her objections to the termination of child support, and her objections at least the downward modification of alimony were without merit. So Brian had reasonable points he brought up. Sarah brought up none and refused to acknowledge anything. Footnote 7, let's just read here. The court notes that there was some merit to respondents' objections to petitioner's request for sole parental responsibility, although she confused and continues to confuse petitioner's request for sole parental responsibility with a request for termination of her parental rights. Because she's an idiot. However, even a meritorious defense on this issue did not justify 1,231 days. No shit. E in the factors, whether the litigation is brought or maintained primarily to harass, or whether a defense is raised mainly to frustrate or stall. Well, I would say Sarah qualifies for that. After being incarcerated for a number of years, respondent continued maintaining her defenses to the modification of child support and alimony even after being convicted of second-degree murder and sentenced to life in prison. Oh, no! Without the possibility of parole. Oh, no. She finally capitulated to the modification of child support at the final hearing, but continued to contest a financial change in circumstances and argued that she was entitled to $1,000 in alimony per month. And it's legally, she's entitled to it, Judge. The existence and course of prior or pending litigation. As noted above, the pre-judgment litigation lasted 197 days versus 1,236. That was 231 days of litigation. Further, respondent continued to drag out the post-judgment proceedings even after she was convicted of second-degree murder. Oh, no. Oops. And sentenced to life in prison without the possibility of parole. Oh! Maybe this should help clarify it for Sarah. She should understand how long she's going to be in there now. Cats or dogs, congratulations on becoming a member. Yeah, well, I don't understand the typos. How do you take 7 months for this ruling? I mean, it's not really her; it's her clerk, right? But she should still read it. Upon evaluating the Rosen factors, the court finds that the majority of respondents' defenses in the post-judgment proceeding were frivolous or spurious, which resulted in unnecessary litigation.
Well, that's because you're an idiot.
I'm saying Sarah's the idiot, not the judge. Therefore, the petitioner is entitled to reasonable attorney's fees and costs provided to provide justice and ensure equity between the parties. The court finds that the $175 paralegal rate and $395 attorney rate are reasonable. Petitioner has shown through competent, substantial evidence reasonable attorney's fees in the amount of $11,668 through July 29, 2025. So that didn't include the trial, but let me add this to the list here. So, Brian gets $11,668 through July 29, 2025. Attorney's fees. The court finds that 8 hours of paralegal time and 8 hours of attorney time for the preparation for and attendance of the final hearing is reasonable for an additional fee reward of $4,560. So $4,560. Petitioner total credit of $16,228. Petitioner will receive a credit of $16,228 from the alimony arrears owed to respondent, leaving an amount alimony arrears balance of $3,992. Thank goodness they did the correct number to subtract, not $22,000. So the $20,220 is reduced by the $16,228, brings us down to $3,992. And what do we know? Brian's getting back $4,000 from the state for the child support. Coincidence? Maybe. It seems like he's just going to go, okay, there it is. It is therefore ordered and judged that the petitioner's petition for modification is granted in part. Petitioner's petition for relocation is granted. Parental responsibility timeshare. Petitioner father shall have sole authority to make major decisions for the child and 100% timesharing with minor child. Visitation. All right. Beginning May 1st, 2026, mothers shall be entitled to 1 telephone call per week with minor child, as well as an additional call on the child's birthday, Thanksgiving Day, and Christmas Day. Okay. Sarah gets 1 call a week plus Thanksgiving, Christmas, and B-Day. Not on her birthday, though. The holiday calls should be in addition to the weekly calls, but each call shall be no longer than 30 minutes unless otherwise agreed upon by the parties. 30 minutes. Length. Well, Sarah's not going to like that. Footnote. See Petitioner's Exhibit number 2. The court deducted $332. The court deducted $332.50 due to 1.9 hours of paralegal time that appeared to be clerical in nature. All right. Well, not that. So it was a little bit of an adjustment. Whatever. Also, beginning May 1st, 2026, or within 30 days of the minor child being approved as a visitor, whichever occurs first, mother shall be entitled to 1 weekend visit per month for 2 hours per visit at the Lowell Correctional Institution main unit in Ocala, Florida. Sarah gets 1 visit. 1 2-hour weekend visit per month. And that's not surprising. Brian didn't fight to have no visits. We've got 1 week, 1 visit. Remember how many she wanted? She wanted the maximum allowable time. Like he's going to be there all day and, every week. The transportation costs for the week of visit shall be allocated to the father. All other provisions of the parenting plan approved by the final judgment, not expressly modified herein, shall remain in full effect. Alimony modification. Effective March 1st, 2020. Petitioner's alimony obligation is hereby modified downward to $145. That's not actually what it's per 2022 because the $15,000 was before, or else you would not have the $20,000. All of the provisions of the marriage settlement agreement approved by the final judgment, not expressly modified herein, shall remain in full effect, including the length of the award of the durational alimony. As a result, petitioner's durational alimony terminated on April 2nd, 2025. Petitioner shall receive a credit of $16,228 for his award of attorney's fees in accordance with paragraph F below. As such, the alimony arrears amount is reset to $3,992. The $3,992 balance of the alimony arrears shall be paid in 7 installments deposited into respondent's inmate trust account. Within 20 days of this final judgment, petitioners shall apply to be an individual who, pursuant to Rule 33-601-716 of the Florida Administrative Code, is identified on the respondent's automated visiting record. Here's the schedule of payments. Petitioner shall make the following payment deposits to respondent's inmate trust account. Within 90 days of petitioner being identified on Sarah K. Boone's automated visiting record with a current approved status pursuant to rule blah, 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 petitioner shall make payment 1 in the amount of $600. All right. On or before December 1st, 2026, petitioner shall make payment number 2 in the amount of $392. So it's quarterly, right? March 1st, 2027, $600. June 1st, 2027, $600. September 1st, 2027, $600. On or before December 1st, 2027, petitioner shall make payment number 6 in the amount of $600. On or before March 1st, 2028, the petitioner shall make payment number 7 in the amount of $600. All of alimony amounts deposits shall be made by cashier's check, money order, or certified bank draft made payable to Correct Pay and mailed with a deposit slip by the due date above, according to FDC inmate deposits. So we know there's a limit, right? And how much can be put into an inmate account. So I'm wondering, the hassle of it, right? Because I'm sure she's going to blow through the money immediately. Because people said that they just get automatic deductions, right? So, but it's funnier to just put it in there and have it be eaten up. And okay, here's the $600. So it means there's no way she's going to be able to enjoy any of this. Child support termination. The father's child support obligation shall be terminated retroactively to February 25, 2020. Yay. Father is entitled to the return of any funds being held by the clerk of court for overpayment of child support at $4,000. The new child support arrears are $0 effective April 7th, 2026. The clerk is directed to return any and all funds being held for child support to petitioner Brian C. Boone. Attorney's fees. Petitioner is awarded $16,228 in attorney's fees and costs and shall receive a credit of this amount from the unpaid alimony arrears. Relocation. Petitioner is permitted to permanently relocate to Gainesville, Florida. All other provisions of the final judgment, marriage settlement agreement, and parenting plan not expressly modified herein shall remain in full effect. The court reserves justification to modify the supplemental final judgment. Reserves jurisdiction. Now, this is something Sarah isn't going to pay attention to, right? But this is important. They can still make it less, Sarah. So don't screw around. Done and ordered at Orange County, Florida, or on the 7th day of April, 2026. There we are. Okay, so let's go over the final amount here. The final note. Let me lower this down. Share this screen. Okay. So in summary, what did Sarah get? The judge found that she is only entitled to $145 worth of monthly alimony after the date of filed for modification. Brian has 100% time sharing of their son. $20,220 in alimony arrears, which is the $15,000 they stipulated to in the during the trial, and then you've got the $145 times 36 months from the date of the modification through the termination, which would have been last month or this month. Sorry, April 2025. Brian gets credit of $11,668 plus the $4,560 for the trial for a total of $16,228. We take the $16,228 out of the $20,220. That leaves $3,992 that Sarah is owed for the back alimony that she didn't ever receive. But Brian gets the $4,000 child support he paid back. So I don't think he'll be struggling to figure out where to come up with that $3,992. But, you know, she's legally entitled to it because he didn't file the modification right away. Oh, well. Sarah gets one call a week for 30 minutes, and she gets 1 hour, one 2-hour visit per month on the weekend. Not maximum allowable time, and once a week. So I'm pretty sure this is good for Brian. I mean, I don't see why Brian would be upset with this. This is everything they asked for. Let's see what you guys are saying on here. All right. Actually, I'll do a little poll here. Let's see. Let's see. Poll. Do you like the judge's ruling? Yes. No, it is unfair. Add an option. Okay, so I'm going to do yes, no, it is unfair. No, but it is fair. Take this one. Okay. No, I don't believe, sir. I thought I saw that in the first one. Calls. I was acknowledging that's who paid for it. I don't know if it's stipulated who has to pay for them. I imagine she has to pay for it because that price was worked into the funds, was it not? Of the $145, which is boils down to the $3,992, which she's going to get paid over the next 3 years. There's no way she's going to be able to enjoy any of this because, like we said, Wicked Rose gifted 10 Hear Me Out memberships. Thank you very much to those, and congratulations to those who received them. Producer for Motown Picture, member for 6 months. Congratulations. Lisa, new member. Congratulations. Right. So there's the daily deduction or whatever. Isn't that how she was always in the negative? I guess Sarah should have taken the $5,000 that she told Peter. Yeah. Well, they said $5 for estimated phone call cost in that 145. Now, the 145 isn't what she's getting paid now. She's not getting that paid to her now. That was the arrearage of the after the modification. So Brian isn't paying her $145. Okay. Do you think the court and prison will take the money Sarah gets? Yeah, I think so. Pay to stay debt. She didn't bring up the pay to stay debt in trial. There's no appeal. It's not a criminal court ruling. $2 SEBA. Well, no, she can file another motion, though. We know she's gonna, right? No way she's not. Great job, Hear Me Out. Congrats on Brian Boone and the little guy. Yes, Faceted Dreamer, $2. Thank you very much. Okay, let's look at these. Can she be penalized for trying to call her son more frequently? I imagine, remember, like, that's the last line in there. The judge retains jurisdiction to modify this. So if she starts going crazy, then Brian can go in with his attorney and request that she not be allowed to call anymore. And the judge can go, yep, you stop, avering to Aver. Okay. Avering is to aver, stating as to facts. Thank you, Sue. If she gets out of line, she can have more stuff taken away. Yeah, she can be held in contempt. So, I don't know what the poll's at. What is it at? What do you guys think? Okay, so we've got so far a third of you think it's, a third of you like it. 20% say no and it's unfair. Half of you say you don't like it, but it is fair. I'm fine with it. I don't know. You can't just, like I said, they weren't asking for her visitation to be removed, right? So why would the judge take away stuff that they weren't asking for? Yeah, it's basically a wash, but he doesn't have to pay it all at once. Which is what I was saying. Like, you pay it if you could. Let's say that the limit on account funds wasn't a thing. You pay it all at once, and you don't have to deal with it anymore. But it's better to spread it out as long as possible because she's going to never be able to utilize it because she's going to be negative. Costs come out of the account immediately. Yep. Yeah. Bottom line, Brian is free and Sarah will hate it. That's right. We've got over 1,000 people here. Excellent. And we've got 462 likes. Only less than half of you like this stream. Go ahead and hit that like button. It's free, people. It's free to hit the like button. Make sure you subscribe as well. We are going to be continuing to do more stuff with, Lauren, obviously. He's always the filler in the meantime. But Sarah should owe Brian child support. kind of gross that she's not being held responsible. They didn't ask for it. They didn't ask for it. Jaws monologue for more likes? No. I wouldn't report it overdue for 2 weeks. Our mission was so secret. No distress signal had been sent. Think about a shark's eyes. Got lifeless eyes like a doll's eyes. Don't seem to be living till it bites you. No, it's a wash in terms of cash flow. Whatever. Like I said, this is everything Brian asked for. So why would Brian be upset? You think? Well, yeah, we're probably reading this before Sarah, because she's so stupid and doesn't know how to get stuff, and she can't get it offline, right? And it's probably being mailed to her. She'll probably get it this week or next week, on Tuesday. Yeah, but like I said, he doesn't care. Brian wanted this done. Yes. Okay. Okay. He got the child support back, basically zero, and he's got timeshare, 100% timeshare. She has no timeshare. She doesn't have any money. What is the point of ruling that she owes back child support? She has no money. This is funnier. To send the payments in 3-month chunks, where she just basically see it vanish. Lauren Armstrong. This is the Lauren channel. I don't know if we might go live tonight with another Lauren. More Lauren calls. I gotta see from X-Derek. X-Derek never showed up. Neither did Suma. I don't know. Thank you everyone for being here. I will put in comments and chapter markers. Let's go ahead and do the outro. Oh. I gotta find the visit. Where's my Sarah Boone visit video? The old trial, or going down to Florida. Anyone see Florida trip? There we go. Hello, everyone. It's Hear Me Out. Yeah, okay. I'll put this up here for the outro. Hello, everyone. It's okay. Once that loads up there, I'll get that. We should end the poll. He never. What do you mean? I sent him. Wait. What are you talking about? Exter was begging to be led into the stream. I sent him the link. He never came into the studio. Yeah, he was here in the chat, but he didn't come up. He has to click on the link. I can't do that for him. I have proof. I have the email receipt. I don't know why this upload is taking so long. Oh, Brian has to pay for the 1 week until he's 18. Okay. Whatever. I mean, he's paying for it by the extent that it's coming out of his, or whatever, the collect call, right? He's not giving the money to Sarah, and plus she doesn't call all the time. She's not going to call. The calls are going to last. How long before we think Sarah loses the phone call and visitation privileges? A couple months? Probably. All right. Thank you, everyone, for being here. We should be live again later tonight, maybe in a couple hours. Probably the Lauren thing. Okay. And hopefully this is the last time we hear Sarah Boone. Bye.
Hello, everyone. It's Hear Me Out with Hear Me Out News, standing outside Publix, which sells enough liquor for two people to have a really good time. No doubt, Sarah spent countless hours here agonizing over which bottom brand wine to choose after they can no longer afford vodka. Let's go in and see if we can find one ourselves. Hello, everyone. It's Hear Me Out with Hear Me Out News again, coming from what no doubt was Sarah's favorite aisle in any store ever, where she would have spent countless hours toiling in anguish over which decision to make. Should it be this Magnum Woodbridge? Should it be this Magnum Woodbridge? After speaking with the store manager, I have confirmed that Woodbridge Magnum sales are down 5,000% since Sarah Boone's incarceration. Now, you can see cattywampus to this all the way over there is the Circle K that George would stop by on the way back. In addition to that, it is starting to rain, and the humidity has officially liquefied my body. And we have finally returned to the scene of the crime. Apartment number 3 is over my shoulder. Let's go closer and see if there are any new details we can uncover. This is apartment 3. I'm not going to knock on it because it doesn't look very inviting. Shutters look broken, possibly and most likely from Sarah's destruction. Locals remain skittish and recluse, with nobody seeming to want to come outside. Although I did approach a small child and asked them, "Do you know who used to live here?" And he ran away to his mother. There is no Kia Sorento in the parking lot. Many residents believe the evil of Sarah Boone still haunts these grounds, with the sound of empty wine bottles clanging together and the sound of a drunken, slurring idiot being audible on several nights. Whether these theories are true or not, they all unanimously agree it is way better than when she actually lived here.